The coaching has won. That's why I told the secretary examination has to be there.
You took long. You state? Listed? Just a minute. Listed?
Yes, may it please Your Worship, Richard Bilivumbuka, Chief State Attorney for Prosecution. My colleagues, Tumusime Kato, Ochida Hope, and Masaba.
Ochida? Mr. Tumusime Kato?
And Masaba Raphael Gideon. All for accused persons on private brief. Your Worship, this matter is coming up today for prosecution's reply to the accused application for bail.
Your Worship, I wish to address God before we get the reply from my land colleague.
Just a minute. Just a minute. Just a minute, Council. Mr. Masaba.
Masaba Raphael Gideon, Your Worship.
Yes, Mr. Masaba.
Your Worship, I pray that before we get the reply from state, Your Worship, I did not appreciate the sensitivity of this matter. That yesterday I received a phone call from one of the sureties informing me that the chairman.
Yesterday I received
A phone call from one of our sureties, that is Nambozo Brenda, the sister to the accused. She informed me that her resident chairman had questioned her why she had not informed him that the person he was introducing had actually abused someone very important. Your Worship, basing on that, we took steps and obtained another letter in respect to this confirming in respect to the accused person.
As a result?
As a result.
You went somewhere else and you picked other letters.
Your Worship, we got a letter from the village where the mother of the accused comes from. And that is in particular Akoli to Sale in Kundaka district.
Akoli
to Sale. It is in Kundaka district. This letter, Your Worship, introduces the mother the suspect.
Objection, Your Worship.
Yes, let's let him pass complete counsel with him. Yes, Mr. Masaba.
Your Worship, this letter in particular,
This letter introduces
the mother of the suspects,
as another surety.
no, and it confirms that during school holidays, the accused, Musana Ibrahim, spends his holidays with the mother. Your Worship, we pray that submit this letter and the mother's photocopy of the mother's national ID.
So it's another. It is an alternative residence for the accused.
Yes, Your Worship.
Yes, let me look at them. Sit with me. Your client is indicated as a businessman. Does he study? On the charge sheet, it reads businessman.
Your Worship is a student.
And also businessman at the same time?
Your Worship, I don't
That's
know
what I
if-
have here. I don't know that I have the
Yes,
same
Your
charge sheet. The charge sheet is indicated that he's a businessman. Later is saying that he's a student and sometimes in holidays he visits the mother.
Yes, Your Worship.
So what does he do?
I push adverts online.
Hmm?
I do online adverts for people who have businesses.
You don't like advertising for people?
Yes.
And so at the same time?
Yes.
Your Worship, I only knew that he holds a TikTok account.
I'm not aware.
That's what I was
I'm not aware of
Your
TikTok
Worship.
account. I'm just reading it. I'm not on TikTok.
Much of confusion.
Your Worship,
Let's proceed with your response. You will address this, I believe.
most obliged. Your Worship, today was the prosecutor's day to respond to the applicant's application for bail.
Yes.
Your Worship, we do appreciate that it is the accused's right to apply for bail.
Just a minute. Let me follow up. I do appreciate.
Yes, that is the applicant's right. Apply for bail. But it is the discretion of this honorable court to grant it or not. When applying for bail, the applicant fronted two sureties. That is the numbers of Brenda and Ibrahim Sembatia Matia. Your Worship, prosecution sought to verify one, the validity of the recommendation letter to the accused person or the applicant. And the recommendation letters, the recommendation letter for the applicant, numbers of Brenda and Ibrahim Sembate. We instructed the police officer, Detective AIP Pamizo Agre, who is the investigating officer, one of the investigating officers in this matter, to ensure a thorough verification of the same. He did so and thereafter swore an affidavit which we filed, my lord, your worship, and served on to accused. Yes, this morning. It's okay. Your worship, let me refer you to the state affidavit, the verification, because it forms key in this. Your worship, to confirm that it is the investigating officer in this matter, we refer you to paragraph 2 of the said affidavit. Paragraph 2 of the said affidavit. And we appreciate, your worship, the fact that this accused person is charged with 4 counts of hate speech and malicious information. That is paragraph 3 of the affidavit. In respect to the accused person himself, your worship, refer to paragraph 6. The letter which introduced him was received, and we annexed it as Annexure 3 in the affidavit. Annexure C.
Yes.
Annexure C. On verification, it was found out that the applicant, who is the accused person, has never been a resident of that place. The chairperson LC1 confirmed that through his letter, which is
He
marked
has never been a resident
of the place which is in the
that set zone. Eh?
yes.
So this is paragraph what?
This is paragraph 7 of the affidavit. His annexure is D. Is marked as D.
So the letter chairman confirmed the next day.
Yes. And your worship, that explains there's some connection between the chairperson's letter and the place where the accused person or the applicant was arrested from. The applicant was arrested from a hotel called Alexis, which is found in Tinda.
How long had he lived in the hotel?
He had been there for 2 consecutive months. Yeah, yes. And the implication of that is that he does not have a fixed place of abode, which is very critical to consider why court is granting or releasing him on bail. Your worship, because the accused person does not have a fixed place of abode, it became extremely difficult for police to locate him and arrest him. I refer you to
Arrest him and
to locate him and arrest him. To locate and arrest him. I refer to paragraph 12 of the affidavit. Your worship, as I submit in that respect, in considering whether or not an accused person is eligible to be released on bail, the place of residence or fixed place of abode plays an important role because it speaks to the credibility of the accused person or the applicant and the possibility of rearresting him in case he absconds bail. And when we talk about a place of abode, we are meaning a fixed place of abode. A fixed place of abode. Which is not here in the instant case. And Your Worship, allow me submit that a situation where an accused person in this respect exhibits no credibility, then who are we to assume his worth? Secondly, failure to have a fixed place of abode makes him a flight risk. Makes him a flight risk. That the chances of him absconding bail in case he's released are so high and in that respect, court cannot assume the risk. Your Worship, I will refer you to the case of Ebya Francis versus Uganda. Ebya Francis versus Uganda. High Court miscellaneous application number 222 of 2021. I'll furnish this court with a ruling on that. I would just want to quote something from that case, Your Worship, which will be critical. That bail is founded on a trust system. Bail is founded on a trust system. And if any or the whole of this trust is put into question, the court cannot assume the risk of releasing the applicant on bail. And this is exactly that is happening in this matter. We pray that this court does not take the risk or assume the risk of releasing him on bail, since the trust in him is in question. Prosecution would have had nothing to say had the applicant proven that he has a fixed place of abode. Your Worship, I wish to submit that in respect to Sembatia Moses, Sembatia Ibrahim. It was, yes. Your Worship, it was, upon verification, it was found out that Sembatia Ibrahim is no longer a resident. Is no longer a resident of the area, which appears which appears in his introduction letter.
You have proof state?
Yes, Your Worship.
Where
I am coming, Your Worship. In verification, Your Worship, in our affidavit,
not paragraph 10?
no. I want to refer you first of all to paragraph 8. Paragraph 8, where we attached his introduction letter, which is in dispute, as annexure F. As annexure F.
Yes.
Then I want to refer you to paragraph 10 of the affidavit, in which the chairperson LC1 was categorically clear that the said surety is no longer a resident of that place.
That's the same of Muzana's one.
Yes. And that letter is marked as annexure G. I refer you to paragraph 10 of the affidavit.
Annexure G.
Annexure G.
Yes. This is Muzana's one. Do letters look alike? Let me have a look at this one. This is on record. Yes, they look alike.
Yes.
Okay. It's annexure. Proceed.
Yes. I'll come back to him as well, as I say I'm up for both. Then, in respect to numbers of render, Your Worship, we attached the letter introducing her as annexure E, as per paragraph 8 of the affidavit. And upon verification, numbers of Brenda is a tenant in one of the in that area, and she does not have a fixed place of abode. She's a resident, but she doesn't have a fixed place of abode.
Can shift any time?
Yes?
You mean she can shift any time?
Yes. And Your Worship will refer you to paragraph 10.
10?
Paragraph 10, yes. No, 9 of the affidavit. Your Worship, allow me to submit about those two sureties jointly. For a surety to be substantial or to be considered substantial, there are several considerations that court must look at. One of them, as I said earlier on, is having a fixed place of abode. Which does not exist in our instant case. The current residence of Sembatia is not known. Nambozo is a tenant who is temporal, that can shift anytime. And the applicant, much as is not a surety, cannot be placed anywhere. Now, the implication in respect to Ibrahim, the applicant, the surety, is that he lied to court, that he has a fixed place of abode. And those are all trust issues. The second thing, Your Worship, that court looks at is whether the surety is capable of meeting the bond terms in case the applicant absconds.
Whether the surety,
Yes,
you're capable of what?
of making good or paying the bond terms, executing the bond in terms of real payment in case the applicant or the accused person absconds. That one is demonstrated through the sureties themselves showing court that they have sounding businesses, which was never the case. They were simply talking about I'm a businessman, business lady in places they couldn't even locate no one can locate the businesses they were talking about. That is one loophole. Two, they have to show that by producing bank statements, which court can look at and stimulate it and say this person is worth entrusting the accused person or the applicant. None of them did that. It is also important to note, Your Worship, that another way of demonstrating that is by furnishing titles. By furnishing titles, land titles in this respect, to show that the surety can, in case the applicant absconds bail, can sell that land. First of all, show that he has a fixed place of abode. Secondly, that he can sell that piece of land and reimburse. This was never done. None of the sureties presented is able to do so. Then the other way, Your Worship, is demonstrating as a surety that they know the applicant and where they live. In which case they are able to control the accused person in case he absconds bail. I want to just refer you. Ibrahim, one of the sureties, simply said he's a friend to the applicant. I don't know whether he's a temporary friend or a permanent friend, but simply said he was a friend to the applicant, and he did not mention to this court that he knows where he stays. Your Worship, that explains why even his residence is not up to date. Your Worship, I'm assuming that these accused persons were released on bail. Won't he go to another hotel? And in case he goes to another hotel, will the sureties be in position to control him practically? None of the sureties has a passport. They don't even have a passport. The best they can do is to use porous borders in case the accused person absconds. And we have an experience of Kakwenza who was charged with the cyber harassment, who ran away. These are things we are talking about, and they are a reality.
Communicate with your lawyers.
You are talking about the sureties, not the accused person. Your Worship, I would like to refer you. I would like to refer you to the case of Mogera John versus Uganda. Mogera John versus Uganda. This is miscellaneous application number 0021 of 2023, 0021 of 2023, International Crimes Division of the High Court. This was by Lady Justice Alice Comhand. Your Worship, while the judge was denying bail to the applicant, she referred or she relied on the ruling of miscellaneous application number 002 of 2022. 002 of 2022 by Honorable Lady Justice Elizabeth Jane Alivisa. Who, on page 11 of that ruling, emphasized the importance of credible sources of income for sureties. And in that case, because the sureties failed to demonstrate that, it was a reason for denial of the bail application. Your Worship, I have a copy of the ruling of 0021 of 2023, and my submissions are based on page 13 of the same. A copy of the same is here, Your Worship. Then also for defense. And Your Worship, just to emphasize that, it is worse, especially when the matter is of public interest. This is a matter of public interest. The treatment given to matters of public interest is different from other matters. And where a court finds that a matter is of public interest, then, Your Worship, Justice Margaret Tibulia, emphasized in miscellaneous applications number 045, 046, and 047 of 2015 on page 10 of that ruling. Where she emphasized that in considering whether an accused person or an applicant should be released on bail, the needs of the society need to be protected. And one of the needs of society is protecting them from lawlessness. Your Worship, in this matter, much as the applicant is innocent until proven guilty, as prosecution, this matter is of public interest. And the only way the public interest can be protected is by keeping the applicant in custody until the matter is complete.
By keeping
the applicant in custody until the matter is complete. The applicant attacked very important persons in this country, that even his life. insecure. And actually being in custody is for his own benefit. Being in custody is for his own benefit. In fact, if I were him, I wouldn't even mention the word application for bail. First of all, Your Worship, I have a copy of this ruling for court.
You are saying that he's safer in prison?
He's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I would refer you to paragraph, just a minute.
J?
Yes, paragraph 5 of the affidavit. From our investigations, Your Worship, is that there were clear signs that if the public just got hold of the applicant, he would be dissected into pieces. So he is safer in custody.
Your Worship, I would like to object to that.
You will get the time to submit. So proceed state.
These are our investigations. You can also present yours. Your Worship, is there submission therefore that the applicant is safer in custody? But besides, it is the applicant is an administrator of Pressure, of a Twitter account called Pressure 24/7. He's the administrator of that account. From my investigation, Pressure at Pressure 24/7.
At pressure what?
At Pressure slice 24/7. I refer to paragraph 11 of the affidavit. I refer to paragraph 11 of the affidavit. TikTok.
Yes.
TikTok. Yeah. Thank you.
Pressure 24/7?
Yes. What is the implication is that once he gets out of custody, the possibility of him deleting and interfering with the investigations are so high. And yet this TikTok account is a source of investigations. Your Worship, I'm not an expert, but once you're an administrator, then you're capable of doing anything on that account which you administer. Besides, that said,
so
Your Worship,
you're saying we'll interfere with the investigation?
yes, exactly.
The conclusion?
Your Worship, I just want to furnish you with a copy of the ruling.
For you and let's one counsel reply the joint.
Thank you, Your Worship.
This is most senior. Post Mr. Masao. Mr. Masao, please do lead the team.
Much of that, Your Worship. Your Worship, I will carefully listen to the Land Chief State Attorney. The Land Chief State Attorney's emotional submissions.
Objection, Your Worship. These are not emotional submissions. These are professional submissions because they are based on law. I pray that you withdraws that.
And so we withdraw the word emotional and then we proceed.
Yes.
Your Worship, with apologies, I withdraw.
Also glad.
I was driven by that because
I'm writing your withdraw because that's an emotional submission.
Your Worship.
Not a minute?
First,
Just a minute. I'm withdrawing what you have said.
much obliged.
Now proceed after withdrawing.
Thank you, Your Worship. Your Worship, to start with, Council submitted that the accused is charged with several offences. Your Worship, looking at these offences, they are not that grave in nature. Your Worship, a quick look at the punishment is between paying a fine and imprisonment of 1 year to 5 years.
What's the maximum period in prison?
That's 5 years, Your Worship. And the minimum is a fine. And Your Worship, this is not a very grave offense, like murder. And even in murder cases, Your Worship, court grants bail. So I invite court to disregard the submissions that the accused has multiple offenses against him as a ground for not granting him bail. Your Worship, counsel submitted that the accused has no fixed place of abode.
And you are saying that he has a fixed of abode where?
Your Worship, we earlier informed the court.
You just says the accused has a fixed place of abode at?
We still maintain that he has a fixed place of abode at Church Zone. And his mother's home during the school holidays in Butaka.
Address me on the residence at Kauga.
Your Worship, I wanted to first address court on the letter recording the residence of the accused. Your Worship, the LC1 does not deny that he authored the first letter introducing the accused person as a resident within Church Zone. Not anywhere in his letter does he deny that he authored that letter. Your Worship, I would like to invite courts to our earlier submission that threats from investigating officers.
So you are saying that the chairman of one was merely threatened?
Yes. He does not even deny authoring the letter introducing the accused person. These were threats by the investigating officer.
If he is from the bank, let's proceed.
Much obliged, Your Worship. Your Worship, though, it was also, a state submitted that and gave an exhibit B, which is a charge sheet, where it is stated that the residence of the accused is Kauga village in Mukono. Your Worship, this is not trial that we are producing evidence. However, we note that the document state is relying on is signed by the officer preparing the charge and the magistrate. We do not have time to examine and find out how was this document prepared and brought in court.
So you are saying that this is a state document?
Yes, Your Worship.
So they know what they wrote?
Yes, Your Worship. And that is the officer preparing the charges. Your Worship, it is an allegation by the investigating officer that he arrested the accused from a hotel in Tisasi, where the accused had stayed for 2 months. Your Worship, there is no any proof or evidence attached to this affidavit that the accused person was actually staying in Tisasi. Your Worship, just as they have provided several evidence on this affidavit, there is no single, even a receipt from the hotel to prove to court. So invite court to actually disregard such evidence that is made by an investigating officer whose task is to ensure that the accused is left in cells. Your Worship, for the first time I had evidence from the bar that the accused is likely to be subjected to mob justice by my colleague. Apart from merely stating this in the affidavit, there is no evidence by the state that actually the accused will be subjected to mob justice. As we can see in court, Your Worship, the sympathizers are so many. I would pray that Your Worship will disregard the prayer of denying the accused the bail, because there is a likelihood of any mob justice on him. And Your Worship, further, the Land Chief State Attorney presented to court that one surety Nambozo Brenda is a tenant and does not have a fixed place of abode. My simple understanding, Your Worship, of having a place of abode is that you have somewhere you reside. The ownership. Your Worship, I back up this with direction number 15 and the Constitution Bail Guidelines for Courts of Judicature, where a court only has to get where considering a surety, court would look at the age, work and residence of the surety, but not that the surety should own a home for him or her to become a sound and substantive surety. Your Worship, the LOC even confirms that actually Brenda is a resident within church zone. So I would pray, Your Worship, that court finds Nambozo Brenda a sister to the accused, Your Worship, she's also older than the accused, so she has influence over the accused person by age, and she will ensure that he appears before court. Further, Your Worship, on the second surety, before this court we introduced Ibrahim Sembatia Matia as a resident of Muzana zone. And Your Worship, during the submissions I heard of Sembatia Moses.
It was withdrawn, and the proper suit we have is Sembatia Matia.
Your Worship, I did not hear counsel withdraw that.
This system records automatically.
Thank you, Your Worship. Your Worship, in this regard, the same spirit we informed the court earlier that the investigating officer has intimidated the LOC1 who introduced the accused person. We still see it on Ibrahim Sembatia Matia. The LOC writes a letter. He does not deny having introduced the surety to court. But he merely asserts that he does not know if the surety is no longer a resident in that area. Your Worship, I would pray that since the surety presented to court the Republic of Uganda national ID, which has not been found to be a forgery, because if it was, a state would have informed us. What should we find? Ibrahim Sembatia Matia as a sound surety. Since he can be easily found based on his national ID and his workplace. Your Worship, we had state submit that the accused is likely to interfere with investigations since he is the administrator of at pressure 24/7. So he's likely to delete. Your Worship, I believe by the time a file was compiled and taken to the state attorney to charge the accused, evidence had been collected that moved the Land Chief State Attorney to sanction the charges against the accused.
So even if he deletes,
The
they will not be
evidence
affected.
Yes, Your Worship. Your Worship, we have 4 charges. We have about 8 counts. If evidence was not there at the time of charging the accused person, they would not have charged all these 8 counts. We believe there is no likelihood of the accused interfering with the investigations. Your Worship, further, that even the investigating officer deposed an affidavit. It is evidence that actually he has collected the evidence. Your Worship, I don't have the authority with me here, but I'd like to cite it for court. This is Pujam versus Republic. PANGU versus Republic. Your Worship, it's the 1973 East Africa Law Reports at page 200. 1973.
East Africa.
Yes, at page 282. Where it was
It's
held.
PANGU.
Yes, versus Republic. It is a 1973 East Africa Law Reports at page 200. It was held that circumstances where an investigating officer has shown an affidavit it is court held that it was a simple act that an allegation, fears or suspicions then the sky is the limit and one can only, then there will be no occasion for bail if court believed that on just a mere allegation, fears and suspicion of the affidavit of the investigating officer. Then the sky will be the limit and there will be no bail. Your Worship, also we had the state attorney mention that the sureties should have businesses